We should probably be able to begin. So tonight's tutorial will focus on legality, the notion of legality, as well as the criteria for lawful decision-making. But before we begin to discuss the topic, I wonder if there's anyone who might want to raise any question or have anything to comment on, especially because we have the legal memorandum due on Monday. So if you might have any questions that you wish to ask, particularly...
Actually, Manjo, I have a question.
Yes, this would be...
It's Jason.
Jason, yes, Jason, yes.
With addressing all the jurisdictional type questions, are you happy with us to make the assumption that we're just addressing this under the ADJR and AAT Act as opposed to common law and the Constitution and the rest of it? Because to fit it all in 1,700 words is quite difficult.
No, I wouldn't say that would be the correct approach, mainly because it's important that we realize that as far as judicial review is concerned, although the ADJR Act would be the primary basis, the primary statutory basis for judicial reviews, common law judicial review is important as well. So what I would rather see in the legal memorandum would be assuming that you think that you need to consider perhaps the Judiciary Act of 1903 or the common law judicial review. It is crucial then, if you want to focus as well, if you want to discuss as well the ADJR Act, that you do not end up kind of just copying and pasting whatever is in the book or in the lecture notes. So just focus on the key points. So, there will be some things which you don't have to discuss in detail. Focus on the key issues. In other words, if it's not crucial for you to be talking about what, if it's not important, for example, to talk about the aggrieved as the applicant, maybe, then don't discuss it. It's not essential for you to cover all the key jurisdictional elements in order for there to be judicial review in detail. So you do not have to discuss in detail each element of what is necessary for there to be judicial review, as far, for example, as the ADJR Act. So that would mean that you have to learn to manage your word count, so that you might just say that for there to be jurisdiction under the ADJR Act, the following elements must be present. And then it's up to you then to focus on which of those elements you'd like to spend more time on. And then that would give you room to probably discuss common law judicial review, or perhaps even the judicial review under the Judiciary Act of 1903. But certainly, it would not be correct to approach it or to limit the discussion solely to the ADJR Act.
Okay, thank you very much.
Okay.
Manjo, can I just ask a question following on?
Sure, go ahead. This would be, hold on. I'm just Melissa, yes.
So you don't want us to explain the specific elements of the ADJR Act. You just want us to say these are the elements and move on.
Yes.
Okay.
The only time you need to explain the element is when it is very relevant to the discussion or to the resolution of the problem. So say, for example, if it's crucial for you to be able to explain what an enactment is, or explain whether the applicant actually has proper standing, then obviously in that case, you need to be able to explicate and elaborate on that element. But otherwise, I don't want to be explaining in detail every single element, because we assume we know that. So what is crucial is for you to be able to identify which issues seem to be quite relevant that relate to any of the elements, and then have a deeper discussion of those specific elements that are crucial to resolving the legal problem that we have in the legal memorandum. Did that make sense?
Yes, it did.
Okay.
Yep.
Okay, other questions? Okay, so I've already muted everyone else. If you wanted to say something, you're going to have to turn on your mic. would there be any other questions that you might have in relation to the legal memorandum or in relation to other topics that we have previously covered?
Hi, Manjo.
Yes.
Steve here.
What was that? Sorry.
Sorry. Yeah, I got in late, so I didn't catch a lot of that. But did you say that we need to mention the Judiciary Act as well in the legal memorandum?
I mean, it's for sure you will have to cover the ADJR Act because that is the most common legal basis for judicial review. So the reason why the ADJR Act in the first place was passed was essentially to allow the citizens more opportunities to have judicial review, because otherwise, prior to the ADJR Act, what you would then have would be common law judicial review or probably the Judiciary Act of 1903, but the opportunities for you to undertake judicial review on the basis of the Judiciary Act of 1903 and certainly on the basis of Section 75 of the Constitution or on the basis of common law judicial review would actually be circumscribed because there are certain elements that you simply have to meet. And they're actually quite difficult to meet. And so therefore, the Commonwealth Parliament decided to pass the ADJR Act in order to broaden the opportunities for citizens or corporations to question decisions of executive bodies or of executive agencies. So having said that, the assumption I would make is that when you come up with an answer to the legal memorandum, you would obviously have to touch upon the ADJR Act. But a question that was raised earlier was whether or not it is possible to just focus solely on the ADJR Act. And the answer is no. So the assumption we have is it is crucial for you to really have a discussion around the ADJR Act. That's crucial because, as I said, as far as judicial review is concerned, the primary mechanism that enables people to question executive decisions and actions would actually be the ADJR Act, because that's the primary statutory basis. But there are instances, as we've discussed before, where you cannot apply for judicial review on the basis of the ADJR Act. For example, it might be possible that the decision of the executive is not based on an enactment. So if the administrative decision of an executive is not based on an enactment, it is therefore clear that you cannot apply for judicial review on the basis of the ADJR Act. So the question then is, do you have any alternative basis in order to apply for judicial review? And you certainly do. You have the Judiciary Act of 1903, you have the constitutional basis for judicial review, which is Section 75 of the Constitution, both under paragraph 3 and paragraph 5. And obviously, you have the common law judicial review. So as far as the legal memorandum is concerned, I would imagine that you need to have a discussion around the ADJR Act, but there might be instances when it might be important or relevant for you to explore judicial review on the basis, for example, of common law judicial review or on the basis of the Judiciary Act of 1903. Okay, so you have to discuss the ADJR Act, but at the same time, your discussion cannot be limited solely to the ADJR Act, because there might be instances when there has to be another legal basis for judicial review outside of the ADJR Act, especially if there are certain elements that cannot be met on the basis of the facts, such as I said, when you're not really dealing with an enactment as the basis for an executive decision or action. So that's what you might have missed, Steve, earlier when there was a question raised on that point.
Thanks, Manjo.
Okay, any other questions that anyone might have?
And Jay, would you mind just confirming the cutoff time on Monday? I was under the impression that it was 11 p.m.
Yes.
I think you have 11 a.m.
Did I? Ah, okay.
I believe so.
Okay, it should be 11 p.m. And, well, I would actually allow submissions up to 11:30 p.m. There won't be any deductions for that. I am of the view that there are instances when at the last minute, it happens that some people cannot submit except that they'd rather do it at the last minute, and there might be some technical difficulties when that happens because everybody begins to submit. So in that case, although I've stated that the cutoff point is actually 11 p.m., I wouldn't mind submissions up to 11:30 p.m., and there won't be any deductions for that. So certainly in the evening, Australian Eastern Time, AEST.
Thank you for that.
Okay, welcome. Okay, got that B. Okay, so will there be anything else? Okay, from Vivian. So we're good? Okay, so let's begin. Yep. So tonight, we're going to be discussing more about judicial review, the criteria for lawful decision-making. And our purpose actually is to kind of dig deeper into the notion of legality, because the notion of legality, in a sense, actually has a special meaning in the context of administrative law, as perhaps to the notion of legality as far as constitutional law is concerned, or probably even as far as civil law is concerned. So legality in the case of judicial review, as you've probably realized, has a more limited meaning. And so that's the purpose of the tutorial, as well as the lecture notes and the readings you probably have gone through. So after discussing this topic, you should then be able to discuss and explain the concept of legality in judicial review, and when an administrative decision is unlawful or contrary to law, and the grounds for judicial review of administrative decisions under common law and under the Administrative Decisions Judicial Review Act of 1977. And so for tonight, we will be focusing on just two tutorial questions, but I believe that on the basis of those two tutorial questions, these should give us enough room to actually fully explore the topic of legality as well as the criteria for lawful decision-making. Okay, so we could probably begin by talking about the first discussion question. And if I could get a volunteer to read the discussion question for us. Can I get a volunteer?
I'll volunteer.
Would that be Sarah? Okay, Sarah. Yes, please, Sarah. Can you read the first discussion question for us?
Okay. Sheldon Wang applied for the Family Tax Benefit FTB with the Department of Human Services DHS on 15th of March 2015, a day after he was granted an Australian permanent residence visa. The ANU Tax System, Family Assistance Act 1999, provided that an Australian permanent resident who has an FTB child, who Wang has, is entitled to the FTB. However, under the new regulations passed by the Minister for Human Services, an Australian permanent resident is eligible for the FTB only if he or she has held that permanent resident status for at least 1 year. On account of the Minister's new regulations, the application of Wang for the FTB was denied. Wang's repeated request to the Minister's delegate to reconsider the DHS decision was denied. Wang has approached you as a solicitor for legal advice. He is thinking of asking the courts to review the administrative decision. In particular, he would like a court to set aside the DHS administrative decision and order the DHS to grant him the FTB. Is a court likely to grant the remedies sought by Wang?
Thank you, Sarah. Think about it for a few seconds, and then when you're ready, can I ask you to just put your answers in the chat box, and then we could take it from there. Okay, very good. There seems to be unanimity in the answer, and the answer is actually correct. Now, can I ask someone to explain the answer? Okay, I'm just reading the answer of Sarah here. Very good. Okay, good. Thank you, Sarah. Thank you, everyone. Would anyone care to explain his or her answer?
Hi, Manjo. It's Vivian.
Vivian, yes, please.
I would say that the court actually can't make the decision to actually grant it because of the because it's the executive's prerogative to actually enforce the law. But they're actually asking, he's actually asking for a policy reconsideration of what the Parliament has actually handed down. And that's not part of the judicial powers, if that makes sense.
Okay. Okay. Any comment to Vivian's answer? Thank you, Vivian. That was good. Would anyone wish to make a comment? Part of Vivian's answer involved, she was saying, if I got it correctly, that to ask the, to undertake judicial review and to ask the court to grant the FTB would in a sense be asking for a reconsideration of the policies that were, that is part of what the Commonwealth of Parliament and presumably the executive have decided upon. So that's, I like that because that's obviously a way of extending the answer. That's good. Can I just get any comment? Comment?
Manjo, it's Margie.
Yes, Maggie.
How I responded to this was I said the court is not likely to grant the remedies sought by Weng. The legal effect of a judicial review is limited in that it can lead to the quashal but not the remaking of an administrative decision. In Green v Daniels, the High Court had an occasion to rule on what constituted as unlawful decision-making. It also clarified that even if a decision was invalid, it was not open to the court to substitute the decision of the decision-maker with its own. And also, I also touched on the matter dealt with was a matter which a reasonable authority would be justified in considering when they were making up their minds what condition should be attached to the grant of the FTB. So, in effect, if the matter is so unreasonable that no reasonable authority could ever come to it, then the courts can interfere. But the condition that an Australian permanent resident is eligible for the FTB only if she or he has held permanent resident status for at least 1 year is perfectly lawful. That's how I answered it anyway.
Sorry, I missed that part, the last part. Maggie.
The last part was I wrote that the condition that an Australian permanent resident is eligible for the FTB only if he or she has held that permanent resident status for at least 1 year is perfectly lawful.
Okay. Why was it perfectly lawful again?
Sorry, just let me bring it up again. Because it wasn't unreasonable. The condition wasn't unreasonable.
Wasn't unreasonable?
No.
Okay. I wonder if I should pursue Vivian's point at this point, or your point about unreasonableness. Well, okay, I'll go back to the point raised by Vivian on kind of a policy reconsideration. But let's pursue that aspect of unreasonableness, Maggie, because you raised it right now. The question I'd like to ask is, hold on. Okay. I have a question for the class here. Okay, I've got a question for the class in terms of the teaching style. I had a feedback from some students last term when I was teaching constitutional law that they ended up getting confused because I ended up digging really deep into the concepts. So there were some students who said they actually preferred that, we stick to the answer and leave it at that. Now, on the point raised by Vivian and on the point raised by Maggie, we could dig deeper into admin law. But the danger there is that some of you may find it confusing because, we seem to be going beyond. what is necessary to answer this problem. So the question I actually have is, would you rather that when we have tutorials, we just stick to providing the simple answer and not bother digging deep into some concepts, which can end up making things confusing? Or would you be prepared to dig deep into certain concepts, even if, you know, that will end up making you think more than you actually need to? Because I don't want to get a feedback saying that, you know, the tutorial is confusing because, you know, we ended up going beyond what was necessary for the answer to be given. So I'm asking the class, what is your preference?
Hi, Manjo. It's Catherine here.
Yes.
Hi there. I was in constitutional last semester, so I know the comments that were and the feedback that was given. I think perhaps more the issue that was raised by some students was that rather than sticking to the actual subject matter of the response, if the discussion took its way to a different part of constitutional law, discussion tended to drift to that part rather than going too much in depth on one particular subject.
I see. Okay. So would it mean, therefore, that it's possible for us to pursue these comments or answers that were given by your classmates? That'll be fine? Okay.
I'm happy with that. If everybody else is, it depends on other people, I guess.
So let's begin by talking about the notion of unreasonableness, and then we go back to Vivian's point about kind of a policy reconsideration. So the point I was making, Maggie, because you said that it was perfectly lawful because you felt that the conditions were reasonable, and therefore the assumption being that if the conditions were unreasonable, therefore the regulations would likely be unlawful. So let me begin by asking, did I understand your point correctly before we pursue it further?
Yes, somewhat, because the way I was looking at it was I asked the question, was that condition only affecting this person, Sheldon Weng, and was it an unreasonable condition? And the answer that I gave was no, I didn't think it was, because it applied to everybody, and I didn't think it was an unreasonable condition. But my interpretation might be wrong.
Okay, so which raises the question, assuming that you have a condition as part of a regulation, or probably even as part of a law, but let's just limit it to a regulation. Assuming that there's a regulation or an instrument which is made on the basis of an enactment, meaning on the basis of primary legislation, such as a law passed by Parliament. Assuming you have an instrument or a regulation or even a bylaw which contains an unreasonable condition, and on the basis of that unreasonable condition, the executive therefore comes up with a decision that is adverse to that of the applicant. The question that I would like to ask is, would that constitute something that is contrary to law and therefore be the basis of judicial review in the context of administrative law? So let me repeat my question because it was an interesting point that Maggie said. So let me just repeat that question. Assuming that, and I won't talk about an enactment, about a statute passed by the Parliament, because the reason, as I will explain later on, will be quite obvious. But for now, let's just assume that a regulation or an instrument or a bylaw has been passed by an executive on the basis of a delegated authority. So there's an enactment, and on the basis of the enactment, there is then a corresponding regulation or instrument or bylaw that is passed. And let's assume that that specific bylaw contains a condition that seems to be unreasonable. And on the basis of that unreasonable condition, that leads to the executive arriving at a decision that is adverse to the interests or contrary to the interests of an applicant. My question then is, would that unreasonable condition constitute illegality or something that is contrary to law that would then found a basis for an application for judicial review? So that's my question. If you could just provide your answers in the chat box before I would like somebody to volunteer to take the floor. So hold on. Well, how would that be answered? Would that be a yes or a no? So if we say yes, what do we mean by yes? If you could just amplify on the yes, just so I know what we mean here, because I think the question was quite lengthy. Yes, what? No, what? So just so I know what you mean. So the question really, if you say yes, it would ground a judicial review, an application for judicial review. No, it would not be the basis for judicial review. That kind of answer. Okay. So we got an answer from Maggie, yes from Rice, yes from Vivian. Okay. How about the others? Catherine says she's confused. Thank you. Was that in relation to that specific question? I think it was. Better if you're confused. So we have an opportunity to elaborate. And this is actually a very crucial point. The issue of unreasonableness is crucial. In fact, we're beginning to touch on the notion of legality here. So I'm glad that, Catherine lost the question. Okay, I will repeat the question. Assuming that there is an instrument or a regulation or a bylaw that is created or passed by an executive, and in that bylaw or regulation or instrument, there is a condition there or there is a provision there that we can consider to be unreasonable. My question is, and assuming that on the basis of that unreasonable condition or provision, it leads to a decision, an executive decision or an administrative decision that is adverse or contrary to the interests of an applicant. My question then is, would that so-called unreasonable condition or provision ground be a basis for a judicial review to be undertaken or to be applied for? So that was the question, Catherine. So it's a yes. Am I getting the answer from everyone else? Am I getting the answer from Steve? From Molly? I'd like you to think about this, because whether you got it correctly or not right now, by thinking about it, you begin to better understand administrative law. And I tell you, this is a very, very crucial point. So it's a good thing if you're confused now. It's probably a good thing if you make a mistake now, because on the basis of that mistake, you then truly understand, begin to understand what administrative law is really all about. From Erin. Okay. So have we exhausted that enough? Have I given everyone sufficient opportunity to provide an answer? So Rice has the answer. Okay. So we're good. Okay. So in other words, there seems to be an agreement in the class, and I'm not sure if I saw any dissent. I may have missed a dissent, but from what I see in the chat box, the common answer seems to be that if there is an unreasonable condition or an unreasonable provision in the instrument, bylaw, or regulation, that can then be the basis for an application for judicial review. So did I get that correctly in terms of me interpreting your answers? Would that be correct? Can I just get a yes or a no? So was I able to properly interpret or articulate the common answer of everyone? Would that be a yes? That's a yes, right? Not seeing anyone. Okay, good. Okay. The thing is, the answer is actually no. Let me repeat. The answer is no. So even if you have an unreasonable condition or an unreasonable provision in an instrument or a bylaw or a regulation, which is considered an enactment actually, which is part of the definition of what enactment means. Even if you actually have a provision or a condition there in a bylaw or instrument or regulation that is unreasonable, that is not the same as the Wednesbury unreasonableness that we understand, or unreasonableness as a ground for judicial review under the ADJR Act. And that is linked to the notion of Vivian's, to Vivian's point about policy reconsiderations. So let me begin by talking about Wednesbury unreasonableness, which I think was covered here. or is it going to be covered later on? So when we speak of witness-bearing unreasonableness, in a sense, we get the sense that because there is a kind of finding by a court that the decision is unreasonable, we assume that the decision, as far as the merits is concerned, is unreasonable because there is no person, no reasonable person could probably arrive at that conclusion. So in a sense, it touches upon the merits. But actually, when you speak of judicial review, and therefore we're speaking of the context of administrative law, the focus is always on the question of legality. But what exactly is legality? Does legality bear on the merits of the decision, meaning the decision itself is contrary to law, or does legality bear upon the process of decision-making itself? Okay, the answer is, it is never within the purview of administrative law to look at the legality of any enactment itself. Let me repeat, it is never within the competence of courts undertaking judicial review to look into the legality or constitutionality of enactment. So, which is why this is different from legality from the context of constitutional law. Okay, so from the context of constitutional law, for instance, it is possible for a person to apply for a law to be invalidated because it is illegal or contrary to the Constitution. And in that case, that's when you might, in that case, you probably cite as a fact that there is a violation of the separation of powers, or you might say that an enactment might be contrary to what is in the Constitution. So there is that notion of illegality there. Now that is distinct. In the context of administrative law, when you speak of legality or illegality, you're only speaking in terms of the process by which decision-making was, in terms of the way that decision-making by the executive was carried out. So when you say, for example, that in the context of unreasonableness, when you say, for example, that the decision was so unreasonable that it met the witness-bearing unreasonableness standard, you're essentially saying that the decision-making process of the executive was contrary to law. But it is not so much the merits itself, but actually the process of decision-making. So that could mean that there is no evidence. So in other words, when you make a decision, you need to make a decision on the basis of available evidence. Or it might mean that you make a decision on the basis of the consideration of relevant criteria when it is required. Or it might mean that when you make a decision, so I am recording this. So if you will notice, when I speak of these things, I'm actually speaking of the process by which the decision is arrived. So when you say, for example, when you make a decision, you're meant to make a decision by ensuring that you do not consider irrelevant considerations. In those cases, you're looking at the process of decision-making. You might also say that it is unreasonable because the person probably had a bias. Again, everything pertains to the process of decision-making. So in other words, when we speak of unreasonableness from the viewpoint of administrative law, it is actually the focus is on the process of decision-making itself. It is never about the merits of an administrative decision. Because as we know, the only agency or tribunal that can examine the merits of a decision would be the AAT, for example. It has to be an administrative tribunal. So therefore, as far as judicial review is concerned, it is of limited scope. It is focused on the legality of decision. And when we speak of the legality of the decision here, it has a more circumscribed meaning so that it focuses more on the process of decision-making. So you would then say that the decision is illegal because it is contrary to law in the sense that, number one, it failed to observe natural justice. Two, it failed to observe requirements, for example, of fairness and lack of bias. You might say that the decision was illegal or contrary to law because there was no evidence. Or you might say that the decision was contrary to law or illegal because certain relevant considerations that were meant to be considered were not considered. Certain irrelevant considerations were considered when they should not have been. So again, if you will notice, the focus is on the process of decision-making itself. Now, constitutional law, on the other hand, focuses on the legality of the law itself. So in other words, when I say law, I'm broadly speaking of not only of an enactment or a statute passed by the Commonwealth Parliament, but I'm also referring to instruments or regulations passed by the executive as part of a delegated legislation or subordinate legislation. So let me repeat. Administrative law does not involve a question of the legality of an instrument or an enactment. That is not part of administrative law. That is a function of constitutional law. Okay, now, having said that, you will come across, and you've probably come across the case of the case of Collector of Customs of New South Wales versus Brian Lawlor Automotive, where the High Court said that notwithstanding the fact that there seems to be a question on the constitutionality of the law or the legality of the law, and in that case, I'm using it in a more constitutional context, okay? So the question, when I speak of, in that Brian Lawlor case, when I spoke of the notion of legality, there was a question of whether the law itself was lawful, okay? Not the decision. So remember, you have a law, you can question the legality of the law or the constitutionality of the law. That is part of constitutional law. On the basis of an enactment or on the basis of a law, the executive makes a decision. That decision by the executive is the subject of administrative law. But if you're attacking the enactment itself, or you're questioning the statute or the instrument itself, that is part of constitutional law and not part of judicial review. Now, having said that, going back to the case of New South Wales, Collector of Customs of New South Wales versus Brian Lawlor Automotive Ltd, the High Court ruled that notwithstanding the fact that there seems to be a question in relation to the legality of the law itself, which means it shouldn't have been admin law. Okay? So notwithstanding the fact that a question seemed to have been raised as to the power of the New South Wales Collector of Customs to order, the requirement of certain bonds to be paid by those who were engaging into the business of import and export. So notwithstanding a question on the legality of the law itself, that did not prevent a judicial review to be undertaken. So even if there might be a question on the legality of the law itself, which is not part of admin law, the fact alone that a question on the constitutionality or legality of a law is raised will not prevent a court undertaking judicial review to actually continue to examine the legality of the executive decision. Okay? So just because somebody would then raise a question on the legality or the constitutionality on the enactment itself will not bar or prevent a court undertaking judicial review to actually examine the legality of the executive decision that was made on the basis of what is said to be an unlawful enactment. Okay, so let me repeat. If you speak, so you're talking of legality from two distinct viewpoints. There's a question of legality of the law or the enactment or the instrument, which is part of a delegated legislation, that belongs to constitutional law. Administrative law is focused on the legality of the executive decision itself. The moment you question the legality of the law, such as pointed out by Vivian, you might be raising questions of the policy being unreasonable, you're heading towards constitutional law straight away. So the focus of admin law, as far as judicial review is concerned, is solely on the executive decision, whether or not it is lawful, whether or not it is according to law. But you do not question the underlying basis of the executive decision itself. You cannot question in an administrative law proceeding or in a judicial review proceeding the legality or constitutionality of an enactment. Okay, questions, comments?
Manjo, thank you for the clarity. Very good. So would it be correct then to say that in response to this question, you would just be answering with regards to the legality of the court and whatever powers they have with regards to the problem, and you wouldn't need to cover anything else? That would be the appropriate answer.
Actually, if I'm looking for a high distinction answer, I would like the approach of Vivian. When she started kind of going into a kind of a providing more substance as to what judicial review really means. When she was getting into the notion of a question of policy reconsideration, that's a high distinction answer. Because you're beginning to go beyond a common answer. A common answer would simply say that according to the case of Green versus Daniels, it is not within the power of a court in a judicial review proceeding to grant an actual remedy that is asked for. So that's the credit or passing answer. So a passing answer would be to say that the case of Green versus Daniels, it is unlikely for the court to grant the remedies sought by Weng because the court, in the case of Green versus Daniels, has clearly said that in undertaking judicial review, a court is limited solely to either quashing the decision or affirming the decision, but it certainly cannot substitute its own decision for that of the original decision maker. Neither is it in a position to vary the decision of the decision maker, nor can a court order the decision maker to act in a certain way. That is a passing answer. But when you say then that the reason why this is so is because when you speak of judicial review, for example, there is the idea that underlying this all is the notion of separation of powers, where courts are meant to defer to the executive as far as policies are concerned, as far as what benefits are to be granted. The courts will only intervene when there is a question of legality that is involved, as far as the process by which the executive decision was arrived at. So the moment you introduce that element of the separation of powers, that becomes a high distinction answer.
Great. Thanks, Manjo.
So there's a point here by Jackie. So you need to ask if the executive applied. Yes. So, yes. So whether or not the executive applied the legislation. So again, there are two things the executive can do here. Okay. One is to come up with an instrument, which is part of the definition of an enactment. Okay, so let me repeat. There are two things on the basis of a primary legislation, on the basis, in other words, of a statute passed by the Commonwealth Parliament. The executive can usually do two things. One, it can pass subordinate legislation in the sense that it passes an instrument or a regulation or a bylaw that provides more detail as to what the primary legislation stated. The second thing that the executive can actually do is to then make a decision on the basis either of the primary legislation or the subordinate legislation, which is the instrument or the regulation or the bylaw. Now, so the question is, what do we need to ask? If the question is the legality of the subordinate legislation, meaning whether or not the executive in coming up with an instrument or bylaw or regulation, whether that bylaw or subordinate legislation was legal, because whether or not it was actually within the constraints of the primary legislation, that is a constitutional law question. That is not an administrative law question. But if the question is whether or not the executive, in applying the primary legislation or in applying an executive instrument, which we assume to be legal and constitutional, okay, so we don't question the legality of the instrument itself or the enactment. The question really is the decision that emanates from the legislation, meaning the enactment that was passed. So that's the question there. It is the decision or the action itself, not the legality of either the primary legislation or the subordinate legislation or the delegated legislation, which refers to the instrument or the regulation or the bylaw that was created or drafted or passed by the executive on the basis of what is known as delegated legislative authority, or what is called as quasi-legislative powers in constitutional law. So we're good with this? Any questions?
Sorry, Manjo, can
Yes.
I ask a question?
Yes.
I was taking some notes down whilst you were talking, and I just want to clarify something about Wensbury unreasonableness. Notes that I've taken down here, and I just want to make sure that this is correct. You said that when you're referring to Wensbury unreasonableness,
Yes.
it means that the process of the executive is contrary to law. Is that what you said?
Decision making, yes.
That's okay. I just wanted to make sure that I wrote that down correctly.
So it's the decision making process, not just the process.
Yep.
Because
Okay.
there are two processes involved. The other one, the one of them, as I said, was to really come up with the subordinate legislation. We're talking of the executive decision making, the process of executive decision making.
Right. Okay.
Now, from Erin, so if it is a question of legislation legality, would the High Court consider this in a case before it? Okay. This is a constitutional law question. Should I answer this or not? So Erin is asking, so if it is a question of legislation legality, would the High Court consider this in a case before it? That's a question considering constitutional law. Should I leave it or should I answer it? Because Jason is saying he's getting confused. I could answer it. So I think we should just leave it. I don't want to get into constitutional law at this point. It just might become confusing. Okay, so let's move on. So let's get to the second discussion question. But thanks anyway, Erin, for raising that point. So let's go to the second discussion question. Can I get a volunteer to read this question for us? Can I get a volunteer? Volunteer, please.
I'll read it.
Thank you.
I'll read it.
Yes, thank you.
This one here, Sheldon Wang applied for the family tax benefit. Am I on the right one?
Yes, it is.
Oh, okay. Sheldon Wang applied for the family tax benefit with the Department of Human Services on the 15th of March 2015, a day after he was granted an Australian permanent residence visa. The new tax system, Family Assistance Act 1999 Commonwealth, provides that an Australian permanent resident who has an FTB child, who Wang has, is entitled to the FTB. However, under the new regulations passed by the Minister of Human Services, an Australian permanent resident is eligible for the FTB only if he or she has held that permanent resident status for at least 1 year. On account of the Minister's new regulations, the application of Wang for the FTB was denied. Wang's repeated request to the Minister's delegate to reconsider the DHS decision was denied. Wang has approached you as a solicitor for legal advice. What legal steps would you suggest? Can't read because of that. Would you suggest and why?
Thank you. I'd like to give you a minute. Everyone a minute to provide his or her answer in the chat box. Wait, are the questions the same or not? Hold on, let me just check. Okay. Hold on, let me just see if something was confusing here. Hold on. Okay. Yep, okay, I got it. The questions are different. What exactly is the legal issue as far as the second question is concerned? So this one was the first one. The first question related primarily to the question of remedies sought by Wang and whether or not a court can grant it. This one, the question is, what legal steps would you suggest? So essentially the question here is judicial review available? So perhaps the more specific question here is judicial review actually available? And in relation to that, why would judicial review be available? From Catherine, the silence may mean we're all confused. Okay.
Sorry, I was reading all the chat. What was that last question, Manjo?
I think the question the question might have been a bit vague. What I'm really trying to drive at here is, given the scenario, would judicial review actually be available?
Does that depend on whether it's applied the correct legislation? So if the new legislation is not retrospective, they should have applied the old legislation. Therefore, there's been a mistake in application.
Yeah. Yes. Actually, the one by Sarah is correct, because what the point I was trying to drive at is it possible to apply for judicial review on the basis of on the basis of a decision, of an executive decision that is made on the basis of a regulation by an executive? So let me repeat that. Can you apply for the judicial review on the basis of an administrative decision having been made on the basis as well of a subordinate legislation? So in other words, you're not relying on a primary legislation such as an act of parliament, but you're relying, the executive decision relies this time simply on an instrument or regulation of the executive. Can you still apply for judicial review if you're questioning the legality of an executive decision that was made on the basis of a subordinate legislation? That's the question.
I think the ADJR Act defines the word enactment to include regulations, but then it goes on to further define that as the regulations were made under another act or ordinance as required by statute.
Very good. Actually, that's the whole point of that discussion question there. For you to be able to see that as far as enactment is concerned, it focuses, there is a broad definition of enactment in the ADJR Act. Okay, so that's one. As far as the ADJR Act is concerned, the definition of what an enactment is broader than primary legislation, or is broader than that being only laws passed by Parliament. So delegated legislation, or meaning subordinate legislation, or instruments or bylaws or regulations passed by the executive on the basis of a primary legislation or delegated authority would still constitute an enactment under the ADJR Act. Okay, so that's good. Are we clear about that? Now, as Royce pointed out, is common law judicial review available? And why is that important as well? Is common law judicial review available? What exactly is the significance here? Okay, from Peter, more flexible, but then, okay, some of you are getting confused, okay, but hopefully we're still there. Okay, Peter is making the point that the common law judicial review is more flexible than the ADGR Act. What do we mean by that? Okay, very good. From iPad. Who's iPad? Is that B? Okay, B. Yeah, so as far as judicial review is concerned, the limitation, the significant limitation of the ADGR Act is that the executive decision must be based on an enactment, broadly defined. So as we said, enactment includes not just the statute passed by the Commonwealth Parliament, it also includes subordinate legislation or instruments, regulations, or bylaws that are passed by the executive on the basis of delegated authority. So that is part of what is known as enactment, which can be, which if there is an executive decision that's made based on an enactment, you can have a judicial review under the ADGR Act. But as pointed out by B, if you look at common law judicial review, it is possible for you to question a decision of the executive, even if that executive decision is not based on an enactment. The point being that actually the executive is able to undertake action or make decisions even in the absence of specific statutory authority. I make that point because I came across a comment, and I haven't had the chance to respond to it yet, but I came across a comment from one of the students saying that, what was the comment there? Saying that the executive cannot act without authority coming from the Commonwealth Parliament. Let me repeat. There was a statement made by a student in our course saying that the executive cannot act unless there is specific legislation coming from the Commonwealth Parliament. That is incorrect. That is very incorrect, okay? Because the power of the executive in the first place is constitutional. The Constitution grants executive powers to the Commonwealth, to the executive. It doesn't require, as a basis for its authority, any empowering legislation coming from the Commonwealth Parliament. That's number one. But secondly, as pointed out by a number of you, there's such a thing as executive power, residual powers, and prerogative powers. So there are inherent powers in the executive that, well, these are called residual powers or prerogative powers that inhere or reside in the executive, being the executive, that enables it to undertake certain actions or make decisions without clear statutory authority coming from without any authority coming from the Commonwealth Parliament, and even in the absence of a constitutional grant. So in other words, even if there were no Australian Commonwealth Constitution, and even if the Commonwealth Parliament did not provide specific powers to the Commonwealth Executive, we would assume that as part of any functioning democracy, we will assume that the executive has certain prerogative powers, certain residual powers that inhere in it, in order for it to be able to allow for laws to be executed, or in order for it to ensure that there is the proper functioning of the government. So let me repeat, even in the absence of a constitutional grant, so even if there were no constitution, or even in the absence of specific legislation coming from the Commonwealth Parliament, we will assume that, especially in the framework of the Australian constitutionalism, we will assume that there are certain powers that are inherent in the executive to act in a certain way. And these are called residual powers or prerogative powers. And specifically, therefore, powers such as the power to enter into contracts, the power to enter into treaties, the power to declare war, the power to control migration, to stop boat refugees, the power to conscript citizens and draft them into the military. These are inherent, recognized by the courts to be prerogative or residual powers in the executive. So even in the absence of a constitutional grant, even in the absence of specific Commonwealth parliamentary legislation, there are certain inherent powers in the executive. So on the one hand, we're suggesting that as far as the ADGR, in relation to this question, therefore, as a way of a review, in relation to this specific question, when it comes to a judicial review under the ADJR Act of 1977, enactment encompasses not just common statutes passed by the Commonwealth Parliament, but enactment also broadly includes instruments and regulations or bylaws that are passed by the executive as a consequence of delegated authority coming from the Commonwealth Parliament. But having said that, when you speak of providing advice, assuming that a decision was not based on an enactment, assuming, and we're speaking in this particular case of Australian National University versus Burns, the point is that you can still have common law judicial review. So it is possible for courts to review decisions made by the executive on the assumption that the executive made a decision that was not based on an enactment. So that was just the whole point of the second discussion question. So would that be clear, or are there any questions that you might have? From Jason, it'd be nice for the executive to tidy this area of law up into one nice act and repeal the rest. Okay, I don't know how that can be done. Okay, there's a question from Erin. So what happens if these inherent powers are used and decisions are wrong or illegal? That goes into constitutional law, Erin. That's a constitutional law question. And I don't want to discuss it. I don't want to answer that question here, but that's a very valid point. But that's a constitutional law question. Vivian, you have a question on common law? What's the question there?
I was just wondering if it's an inherent powers are used and decisions are wrong or illegal, can that be reviewed under the common law judicial review?
If you're answering the question of Erin here?
Yes. Can common law judicial review actually come in when there's the inherent powers are actually used and decisions are made that are wrong or illegal? Can't they be reviewed by the common law, by the courts under the common law as being illegal?
Yes. Now, we must note that there are two aspects to the question of Erin, actually. The first aspect is the exercise of the inherent powers being wrongful or illegal. So what it broadly means is that it's possible that it can be argued that the exercise of executive powers was beyond the power of the executive in the first place. That is a constitutional law question. In other words, it may appear that the exercise of certain executive powers encroaches on the powers of the legislature or encroaches on the powers of the executive. That's one part, the way that I would see Erin's question. Now, the other part that you've raised, Vivian, relates to decisions made by the executive. Okay, so that is based on executive decisions that appear to be wrong or illegal on the basis. So we make the assumption on the other hand, that the executive is exercising its inherent powers. As a result of exercising those inherent powers, it arrives at decisions. But those decisions are then considered wrongful or illegal. So in that case, our focus is on the decision itself or on the illegality of the decision. So if the focus is on the illegality of the decision, and that executive decision had been made not on the basis of an enactment, but on the inherent powers of the executive, the answer is yes, you can have common law judicial review. But if the question, on the other hand, was an illegal exercise of inherent powers because it seemed to have encroached upon the powers, for example, of the legislature, or the powers of the courts, or it may involve the exercise by the Commonwealth executive that encroaches on state executive powers, that becomes a constitutional law question, which I don't want to get into. So for as long as the focus is on the executive decision itself and not on the underlying power on which the decision was based, that's part of judicial review. But the moment you begin to question the legality of the underlying power itself, that becomes a constitutional law question. Okay, from Rice, when you speak of common law judicial review, are you including Judiciary Act? So as far as the Judiciary Act is concerned, because the Judiciary Act is a statute, so what you have is therefore a statutory judicial review. In that case, you speak of a statutory judicial review. So it is a judicial review on the basis of a statute, which is the Judiciary Act of 1903. The common law judicial review is totally different because it involves the assertion by the courts of its inherent power to control or review the exercise of executive powers. So in times past in the UK, primarily on the basis of what is known as the Orange Revolution, there was a time when the courts asserted their authority because okay, we're going just a bit deep, a little bit into constitutional law, but just to provide a background about common law judicial review. Okay, if you trace the history of England and remember that a lot of what goes on as law in Australia is based on obviously on the UK and in England. So there was a time when the King of England was considered supreme as the monarch. You know, whatever the monarch said was the law. And therefore, what the monarch said couldn't be questioned because he was meant to be the law. What he said was the law. But in the so-called days of the Orange Revolution, where there was a battle between the powers of the courts and the king, and the courts eventually won, and the parliament actually won. And that's the reason why you ended up with what is known as parliamentary supremacy in the UK, okay, where courts cannot even question the legality or constitutionality of parliamentary laws of parliament. So there was a time when the courts asserted their power to control the excesses of the executive. So that's part of history. So courts asserted and won that battle with the monarch when they said that it is within the inherent power of the courts to actually review the decisions or actions of the executive that were contrary to law as part of the notion of democracy or as part of the notion of rule of law. So that is what is known as common law judicial review. The exercise by the courts or the assertion by the courts of the inherent right or power to control or review decisions made by the executive when those decisions appear to be contrary to law. That is common law judicial review. When you speak of statutory judicial review, you're speaking of judicial review that is done by the courts on the basis of a law that is passed by the parliament. Because remember, under the Constitution, and we're kind of going a bit to the Constitution here, if you look at Section 77, it is within the power of the Commonwealth Parliament actually to determine the jurisdiction of courts. So in that case, you know, they can create courts and they can define the jurisdiction of courts. And in doing so, what they did was to come up with the ADJR Act. So in other words, the Judiciary Act, in the same manner that the ADJR Act is concerned, they're both statutory judicial reviews. Okay, so you have judicial review on the basis of an enactment of the parliament. Common law judicial review is solely based on the assertion by the courts of their inherent power to control or temper the exercise of executive decision-making when such decisions or actions appear to be contrary to law. Okay, questions? Okay, so from Melissa, how do the ADJR Act and the Judiciary Act work together? Okay, the answer is this way. My head hurts. Okay, we're still good, right? Are you happy for us to proceed into the details here? Okay, so as far as the ADJR Act is concerned, what we need to remember is that the court can only undertake judicial review on the basis of an executive decision that was based on an enactment. So under the ADJR Act, a crucial jurisdictional element there is that the administrative decision must have been based on an enactment that is broadly defined. Okay? So therefore, as we said, there are certain instances when the executive decision is not based on an enactment. So in that case, If an executive decision was not based on an enactment, then you cannot have recourse under the ADJR Act. So you cannot have recourse for judicial review under the ADJR Act if the administrative decision is not based on an enactment, because the ADJR Act is quite clear that courts can only have power of judicial review if an executive decision is based on an enactment. Now, where does the Judiciary Act come in? Section 39B of the Judiciary Act of 1903 is almost a similar provision to Section 75, Paragraph 5 and Paragraph 3 of the Australian Commonwealth Constitution, where it provides that in relation to the Judiciary Act of 1903, Section 39B, where it provides that the Federal Court of Australia, as well as the Federal Circuit Court of Australia, has the power to issue writs of mandamus, prohibition, or injunction in relation to officers of the Commonwealth. So, under the Judiciary Act of 1903, which is very similar to Section 75, 5 and 3 of the Australian Commonwealth Constitution. So under the Judiciary Act of 1903, Section 39B, the Federal Court of Australia, as well as the Federal Circuit Court of Australia, has the power to issue writs of mandamus, prohibition, or injunction against officers of the Commonwealth. So you will notice, therefore, that in relation to that specific provision, Section 39B, there is no requirement that the application for judicial review under the Judiciary Act is based on an executive decision that is based on an enactment. There is no requirement. So for as long as what an applicant asks for is a writ of prohibition, mandamus, or injunction, regardless of whether or not the executive decision was based on an enactment, you can have recourse to the Judiciary Act. Okay, so if you cannot apply for judicial review under the ADJR Act because the executive decision is not based on an enactment, then you might consider applying for judicial review under the Judiciary Act of 1903, particularly Section 39B, if you believe that there is a legal basis for the grant of a writ of prohibition, mandamus, or injunction. And yes. What was that?
Sorry, can I just clarify one thing then?
Yes.
If you do find, if the decision was made on an enactment and you do have grounds, you would go through the ADJR Act rather than the Judiciary Act.
Yes. Yes.
Thank you.
And Manjo, would it be
hold on. And as Bryce pointed out, good point, the ADJR Act also excludes several enactments. So there are certain enactments that are excluded, such as decisions based on the ASIO, for example, on the Australian Security Intelligence Organization. That would be excluded by the ADJR Act, or perhaps even decisions by the Governor General. Okay, so there are therefore, very good, Rice, thank you for raising that. So under the ADJR Act, you've also got a problem because even if it's based on an enactment, there are certain enactments that are excluded from review, from judicial review, on the basis of the ADJR Act. So particularly, as Maggie pointed out, Schedule 1. So in that case, if you can't have recourse to the ADJR Act, one, because it is not based on an enactment, and two, because it is an excluded enactment, then you will have to consider the Judiciary Act of 1903 or a common law judicial review. Well, there was a question. What was the question there?
Manjo, I was going to ask you, following on from the ADJR Act.
Yes.
Then you would determine if the legislation permitted review by the AAT, then you could follow that path. But if the legislation didn't specify that you could have a review to the AAT,
Maggie,
you
got, I couldn't hear parts of what you were saying. Do you mind repeating because yourself? There were parts I couldn't hear. Sorry.
Can you hear me now?
I could.
So my question, I was just going to ask, following on from where it was identified that it was the ADJR Act, you then can only apply for a review to the AAT if it specifies that in the legislation. Is that correct?
Yeah. So as far as the Administrative Appeals Tribunal Act of 1975 is concerned, the rule is that an enactment must specifically provide for review by the AAT.
And then following on from that,
So
there would be only grounds for a judicial review if it was based on a on legality, correct?
Yes. So you will notice, therefore, that the merits review, in a sense, is actually more encompassing, because not only do they actually look at the merits of the decision, they're actually in a position to also look at the decision-making process itself. So in a sense, they're actually touching on the legality of the decision-making process itself. Because remember, they're in a position to actually substitute their own judgment for that of the original decision-maker. And they're primarily allowed to do a trial de novo. So when you speak of a merits review, therefore, you might actually say that it's broader in the sense that it's not a question of just looking at the factual correctness of a decision or the preferable decision. It's actually possible for you to ask the AAT to review whether or not the process by which a decision was made was actually according to law, or whether or not it was illegal. So you can raise questions of the questions of natural justice, which is a ground under the Judiciary Act. You can use it as a ground to question the decision of the decision maker in the AAT. However, as we said, the problem with the merits review under the AAT Act of 1975 is that the enactment, there are about 400 of them now, an enactment must specifically provide for recourse to the AAT. So in other words, if you're dealing with an administrative decision, and even if it is based on an enactment, but that enactment does not provide for review by the AAT, then you don't have a choice. You don't have recourse to a merits review. And that's then where you will be forced to consider whether or not judicial review is possible. And in that case, again, that goes to the question of, if you go for judicial review, are you actually looking at legality of the decision, or are you actually looking at merits? Because merits, a review of the merits is not permitted in a judicial review. Okay, so it's now 8:40. Would there be any other questions?
I'd really like some clarification on one thing, please.
Yes. Who was this? Who would this be?
Sarah.
Sarah. Yes, go ahead, Sarah.
You've often said that the court won't compel, it won't substitute its decision, obviously, for the in a judicial review, and it won't compel anyone to do anything. But Section 16 of the ADJR Act says that the court can make an order directing any of the parties to do, refrain from doing, and so on.
That's right.
That is different to a writ of mandamus.
Yes.
Yes. And then there's a case, R and Anderson, ex parte iPcare Proprietary Limited.
Yes.
And that it says that a court does not direct discretion to be exercised in a particular manner, but confines itself to commanding the officer by a writ of mandamus to perform his duty by exercising the discretion according to law.
Yes.
Is that case under the Judiciary Act then?
The question is, I think the better question is, was there a contradictory statement somewhere?
Yeah, I'm just not sort of seeing the consistency between, as far as you say the court won't direct anyone to do anything, but the ADJR Act seems to be in direct contradiction to that. The common law seems to support what you're saying. And then this case, I don't understand the difference between a writ of mandamus and compelling a court action. Except if there's no discretion allowed. I obviously understand that.
That's right. So we begin with kind of trying to clarify what exactly does Section 16 of the ADJR Act mean. Is that equivalent to providing the courts the power to order the executive to act in a certain way? as in, for example, to order the executive to provide benefits when the court feels that the payment of benefits, for example, is warranted under the circumstances. My view is that
that's discretion, but we're not going to order it if there's a discretion.
Yeah, that's right. So my reading of Section 16, and there hasn't really been much case that I have come across on this point, but my reading of Section 16 of the ADJ Act is that even though it has the power to act, to ask the parties to act in a certain way, it is not acting in a certain way in the sense that the courts have the power to order the executive to act in a certain way, such as by granting, for example, benefits that are requested by an applicant, because that would be contrary to the clear decision of the High Court in Green versus Daniel. So what exactly does Section 16 mean? I would think that specific provision is limited in the sense that it could order the parties, number one, for example, to accept certain documents to be submitted. It could order certain parties to probably conduct, a hearing. So it's more of a limited order to act in a certain way, or probably even to provide reasons. But it cannot be the power that is equivalent, for example, to a power by the court to order the executive to act in such a manner as, for example, certain benefits being provided. Okay, so
how is that different from the case of R. and Anderson, ex parte IPEC Air, when it says confines itself to commanding the officer by writ of mandamus to perform his duty by exercising the discretion according to law?
Okay.
That's not ordering them to do something, that's ordering them to use their discretion.
So we make a distinction again. So on the one hand, we were talking earlier of Section 16 of the ADJ Act. Now we're talking of the issuance of a writ of mandamus. Okay? In that case, that is not on the basis of the ADJ Act. The writ of mandamus is based, one, on the Constitution, which is Section 75. It's also based on the ADJ. It's also based on the Judiciary Act of 1903. It could also be based on a common law judicial review. What it essentially means is that the writ of mandamus is issued when the court determines that it is a matter of right for an applicant to be granted the remedy that he is asking for. So let me repeat, a writ of mandamus can only be issued when the court makes a finding that the applicant is entitled to the remedy or to a benefit as a matter of right. So in other words, if the remedy or the prayer that an applicant asks for is not a matter of right, first because it involves the exercise of a discretion, or two, it cannot be a matter of right because there are certain factual circumstances that the applicant, for example, has not met. In that case, a writ of mandamus cannot be issued. So the writs of mandamus, prohibition, and injunction can only be issued in very constrained, limited circumstances. So when there is... Go ahead.
That's what's confusing me. This case seems to be in direct contradiction to what you've just said.
Why is that?
It's saying even then a court does not direct that the discretion be exercised in a particular manner, not expressly required by law, but confines itself to commanding the officer by writ of mandamus to perform his duty by exercising the discretion. So he's directing an officer to exercise discretion.
That's right. No, there is no contradiction there. What the court in that case said was that when an executive has a power to exercise, meaning he is meant to exercise his power, the executive cannot refuse to exercise that power. Let me repeat. If the executive has been empowered to act, meaning he has to do something, and the executive refuses to undertake to perform or exercise that power, the court can command that executive to act or to perform that power. That's what the decision means. But it cannot direct the executive to act in a certain way. The court, however, is saying that it can command the executive to exercise its discretion. So the executive cannot say, I will not exercise my discretion. The executive cannot do that if there is a law that says that it must. So if the executive says it refuses to exercise its discretion, it is within the power of the courts, as pointed out by the case, to command the executive to exercise its discretion. But in doing so, it will not command the executive to exercise its discretion in a specific way, because that's exactly the point of a discretion. It allows the executive.
Isn't that the same as Section 16 of the ADJR Act?
Which is?
That the court may make an order directing any of the parties to do or refrain from doing. It's just remitting an order back to a decision maker with recommendations.
As I said, avoid reading into that provision something broader than should traditionally be understood as part of judicial review. So what I'm saying here is that as far as Section 16 of the ADJR Act, do not read into that the power of the court to order the executive to act in a specific way, because that will be contrary to Green versus Daniels. And that will also be contrary to the principle of separation of powers. Because under the principle of separation of powers, the courts, because the executive and especially the legislature are under the notion of representative democracy, are understood to be the elected officials of the people, and this brings back to that notion of justiciability, the courts will actually refrain from interfering with decisions of the executive when it involves discretion, because in that case they are exercising certain powers that inhere in them as elected officials of the executive. So we have to read into everything the notion as well of separation of powers. So going back to Section 16, what I am saying here is avoid reading into that provision as if it is a blanket authority on the part of the courts to actually order the executive to act in a certain way. That is not the intention of Section 16. Bearing in mind Green versus Daniels, and bearing in mind the notion of partial separation of powers in Australia.
Thank you.
Okay. Do we have any other questions?
I have a very, very quick one to know it's getting late. It's Catherine.
Yeah, it is. It's 8:50. Okay. So I guess it's about time that we end it. We've gone beyond time. It's 1 hour and 30 minutes now. So I thank you again for being part of this tutorial. If you've got any questions, flick me an email and let's look into that. And don't forget to submit your legal memorandum. And all the best in your submission. The other thing is, chances are, we're not going to have the tutorial on Monday actually, because I'm scheduled for an emergency surgical operation on Monday, which will knock me out the whole night. I'll be confined in a hospital, so it's an emergency medical surgery I have to go through. So I'll have to reschedule the tutorial probably on Tuesday or Wednesday, which is actually good because it gives you time to prepare for the legal memorandum. So I guess we leave it at that, and I'll see you.
Just before you go, when you consider the options for what night you're going to do that, we have a corporations Zoom on Wednesday night, so it might conflict if you make it for them.
Okay, I'll keep that in mind, Jason. Thank you. Thank you. Okay, so good night, everyone. Have a great weekend. I'll catch you next week and all. Yeah. Okay. Thank you. Bye.